If your I-485 just got denied, the next few days could decide whether you stay in this country or leave it, and most people have no idea which category they fall into. The key issue is how much unlawful presence you already have, because that can determine whether you can stay, transfer the case, or need a waiver. In this video, I'll walk through the main scenarios, explain when an I-485 denial still leaves room to keep going, and show when consular processing may be the next step. This is general information only and not legal advice. Here's the group everyone wishes they were in. Under 180 days of unlawful presence, and your options are still wide open. So, for example, let's say you came in as a tourist or a student, or through any other lawful non-immigrant stay, and you had not overstayed at all. Before that period expired, you filed for adjustment of status. Then, for a reason tied to the new policy guidance, and not because of fraud, a crime, or some other separate issue, the USCIS officer denies the application. The day after that denial, you would have 1 day of unlawful presence, because up until then you had no unlawful presence at all. You were in lawful non-immigrant status, and before that status expired, you had already filed the I-485. Even if you entered on a 6-month tourist admission, once the I-485 was pending, you could remain in an authorized period of stay while the application was being processed, even if it took 2 years or longer. So, 2.5 years after entry, you could still be in an authorized stay in this example. Then you learn that the I-485 was denied, and the following day is the first day of unlawful presence. If you stay under 180 days of unlawful presence, and you do not have other inadmissibility issues like fraud, a criminal problem, or one of the other bars that can apply, then you may be able to move the case to a consulate abroad, assuming you already have an approved I-130 petition, which is usually what happens in family cases. At the USCIS interview, the I-130 is often approved if the officer believes the marriage is real, or if the family relationship you are trying to prove, whether that means a parent or a child petition, is genuine. After that, the I-485 can still be denied under this policy. Once the I-130 is approved, consular processing becomes possible, and as long as you do not have more than 180 days of unlawful presence, that path usually moves more smoothly, unless you are from a country subject to special entry restrictions. In those cases, coming back to the United States can take a much longer time. The transfer is generally handled by filing Form I-824, which asks USCIS to send the approved I-130 to the National Visa Center, and then you go through the usual consular process from there. I have explained that process in other videos, because the steps can matter a lot depending on the facts of the case and the type of relationship involved. But here's the scenario nobody wants to end up in. You don't leave, and now you're staring down a notice to appear. In that situation, you will probably receive a notice to appear and be placed into removal proceedings. At that point, you can ask for adjustment of status as a defense to removal. Adjustment of status can be filed affirmatively with USCIS, but it can also be raised as a defense in immigration court. That route is usually more expensive, but it is still a real option, and many people continue to pursue adjustment of status that way. If you remain eligible, the immigration judge can still approve the case. Now, here's where it gets a lot messier. 5 years of unlawful presence, a marriage to a U.S. citizen, and a denial that changes everything. Suppose you overstayed a tourist visa, a J-1 visa, or a student visa such as F1 or M. As long as you are not dealing with one of the visa categories that blocks adjustment, like a crew member case or certain fiancé situations, and you did not marry the petitioning U.S. citizen, adjustment may not be available in the ordinary way. There are limited exceptions in some cases, but under the current policies, they can be difficult to use successfully. So let's say you have 5 years of unlawful presence because you overstayed 5 years ago. Then you marry a U.S. citizen. You file for adjustment of status, and for a reason tied to the new policy memo, the case is denied as a matter of discretion rather than because of a separate inadmissibility finding. At that point, transferring the case to a consulate abroad becomes more complicated Because the moment you leave the United States to attend the consular interview, you can trigger the 10-year bar and make coming back much harder. Before you leave, you would generally need an approved I-601A, which is a provisional unlawful presence waiver, or you would need to go to the consular interview and have the consulate make a formal inadmissibility determination based on the 10-year bar. Once that happens, you can file Form I-601 at the consular stage. If that waiver is approved, it removes the unlawful presence problem, and if your country is not subject to special restrictions, you can receive an immigrant visa and re-enter the United States as a lawful permanent resident. So, should you leave or stay and fight? This is the question I get asked more than almost any other, and the honest answer is that it depends on how comfortable you are with the risk and on the details of the case. My general preference, when the option is available, is to adjust status from within the United States. You usually have more procedural and regulatory protections when you are inside the country. USCIS also tends to be more predictable than many consular posts, which can feel less structured and less consistent. For many people who overstayed, it can make sense to fight the case in removal proceedings and apply for adjustment of status here rather than leave and wait potentially years for a waiver to be approved abroad. But that is not always the right answer. It is a fact-specific inquiry, and there are more things to consider than just what I can cover in a short video like this. So if you are deciding on a strategy, or you are thinking about filing for adjustment of status, it is worth reviewing the facts carefully with a qualified immigration attorney, because the right move depends on timing, prior status, unlawful presence, and the type of petition involved. And if this explanation helped, please like the video, comment with the topic you want me to cover next, and subscribe for more immigration updates and deeper dives into this policy memo. If you want more videos on adjustment of status, removal of conditions, citizenship, naturalization, family-based immigration, consular processing, and waivers, stay tuned, and I'll see you next time.